What is international law and how does this even make sense? I mean, where are the law books? Who are the legislators? If I wanted to complain about international law, who do I complain to? Who has the power to change international law for the better? And why is this topic even worth discussing? It's important because we seem to have a lot of problems that tend to cross national boundaries. Air pollution has this bad habit of drifting into other countries. So does water pollution in some areas, and in a lot of areas if we include the oceans. There's the issue of climate change. It does no good for one country to reduce its carbon emissions if it's the only country, and other countries grow in wealth and power by not doing so. Not to mention the problem of one country's carbon emissions wiping out another country entirely due to sea level rise. And as if to prove that the universe has a sense of humor, if we do manage to cut down on the demand for fossil fuels, this means that the price of fossil fuels will drop. And when the price drops, somebody else can profit by using fossil fuels at the lower price. Besides, what should we say to those countries that are built on and depend on fossil fuel sales? Tough luck, I guess you'll have to starve. There's also a problem with tax havens. Countries have trouble taxing the wealthiest members of their communities because of the ease with which those individuals and corporations can transfer wealth across national boundaries. One way to solve this problem would be to establish a global or international tax code, but how would that work? In fact, that raises the question how our nations do interact with international corporations. Walmart's operating expenses for 1 year is the same as the gross domestic product, the total value of all goods and services bought and sold, in Sweden in a year, about $600 billion. What rules govern the use of international waters, both in terms of navigation and natural resources such as fish? And what rules govern minerals on the deep sea floor? For example, there's this huge field of manganese nodules between Mexico and Hawaii in international waters, golf ball sized lumps of metal waiting to be picked up and sent off to the refinery. What rules govern space? Who will own Mars or the asteroids? When planets form, they get hot and all of the heavy metals settle to the bottom and lighter metals float on top. There was once a planet between Mars and Jupiter, but it got blown apart in a collision. The asteroid Psyche is thought to be the remains of that planet's core, a lump of iron, silver, gold, and platinum 150 miles in diameter. And finally, for most of human history, 1/4 to 1/3 of the population died a violent death. Currently, the chance of dying a violent death is less than 0.1%. Wars of conquest are now virtually non-existent, and a system of international law exists to settle disputes between countries. Obviously, it hasn't worked perfectly, but then laws against rape and murder haven't eliminated rape and murder either. So there are lots of reasons to be concerned about international law. Now, when it comes to understanding international law, it's useful to start with some history. The 30 Years' War from 1618 to 1648 was mostly fought over matters of religion between the Catholics, the Lutherans, and the Calvinists. Pretty much each of them thought that they were the one true religion and the others were heretics and unbelievers. The 30 Years' War started in the province of Bohemia under Emperor Ferdinand II. Bohemia was a Protestant province. Ferdinand was a Catholic emperor who swore that he would rather see his kingdom destroyed than have it contain heresy, such as Protestantism. When the officials in Bohemia met with Ferdinand's two Catholic representatives, they threw the representatives out a window. The representatives survived, but the war was on. And this was a truly horrendous war. There were armies marching back and forth in the lands, taking anything they needed from the farms. Farmers quit their farms and fled to the cities for protection. Food was scarce. The cities were not only crowded with people, but with rats. Diseases such as cholera, typhoid, bubonic plague, dysentery, and the like were rampant. Between the violence and the disease, the population of Central Europe dropped from around 18 million to 12 million. And the life for those who survived was no picnic. There wasn't enough food for a picnic. What's relevant for our purposes is how this ended, with the Treaty of Westphalia. This treaty, in a sense, invented the notion of a nation-state, a region of land controlled by some governing body that others had no right to interfere with. Specifically, countries couldn't invade other countries to restore or establish the one true faith, whichever faith that happened to be. Nations agreed to leave each other alone on matters of religion. It was the start of the notion of freedom of religion, but between countries, not within countries, not yet. This started a pattern where violent conflicts resulted in nations adopting treaties and conventions that aimed to prevent the next violent conflict. The next big step were the Hague Conventions of 1899 and 1907. This established the Permanent Court of Arbitration to resolve disputes between countries, although World War I showed that some more work needed to be done if this was going to actually prevent wars. After World War I, we got the League of Nations, a somewhat larger and more involved international body for the prevention of war. But it didn't work out as well as one might have hoped either. 20 years after World War I ended, World War II began. After World War II, we got the United Nations. And with the United Nations, we got the International Court of Justice. So now we have a court. But the question still exists. What are the laws that this court is going to apply? That question was answered in Article 38 of the treaty that established the International Court of Justice. Article 38 specifies what the judges on the International Court of Justice should look at when answering any question put before it. First, the judges are to look at any relevant international treaties and conventions applicable to the case. Since every country that is a member of the United Nations is a party to its treaty, this provides one common set of rules applicable to all members. However, there are many other treaties that only some members have signed and others have not. Whatever treaties and conventions are applicable are relevant in deciding a case. Second, judges are to appeal to international customs. Now, there's actually a case in which the U.S. Supreme Court based a decision on international customs, and I can use this to illustrate how this is supposed to work. During the Spanish-American War, the U.S. set up a blockade of Cuba. The blockade seized a pair of fishing vessels, the Pocket Habana and the Lola. In hundreds of years of warfare, nations have recognized that fishing vessels are an exception to a blockade. The U.S. Supreme Court ruled that those international customs are presumed binding on the U.S. unless the U.S. government explicitly rejects them. As a result, the Supreme Court ordered the release of the two fishing vessels. Now, also in accordance with Article 38, judges can look at general principles of law. These are principles such as the right to be heard, a right to call witnesses in one's defense, principles of fair play, rights of disclosure, truth under oath, rights of fair warning. They don't need to be stated to be applicable. And last, judges can appeal to past judicial decisions and the publications of expert jurists. Note that the International Court of Justice can't cite these as the reasons for a decision. They can only use the first three items already mentioned to fill that role. However, they can appeal to precedent and professional publications to explain and clarify a decision. Now, I want to note that one of the things that's not included on this list that some people might expect are United Nations resolutions. They aren't counted as a part of international law. The resolutions are not on the list. So the International Court of Justice has no authority to enforce UN resolutions. Now, there are, of course, some issues with this new system. First, the court doesn't have an enforcement mechanism. There's no United Nations police force that can go out, arrest people, bring them into the court, arraign them, convict them, and enforce punishment. This means that it depends on member states to enforce its decisions or on voluntary compliance. And of course, it's easier to force compliance on weaker countries than it is on stronger countries. Iraq invaded its neighbor Kuwait in 1990 in violation of international law, and an international coalition put together by the United States pushes it back across the borders in 1991. However, Russia invades the Ukraine in the year 2022 against international law, and the war continues. The court is also governed by a principle of consent. In order to be bound by a treaty or convention, one has to be one of the signers of that treaty or convention. Now, imagine living in a country where one only had to obey the laws one explicitly agreed to obey. Imagine a driver pulled over for speeding, saying to the police, "I didn't sign on to the law of speeding, so the law doesn't apply to me." So there is an international court that's enforcing international law. It exists even though there's no global emperor or parliament, there's no law books filled with statutes, and there are questions to be asked and answered about how this apparatus should be working, and if perhaps some changes should be made.